Tried a lot of people there. He's going to be the guy. He's going to drive in 80 to 100 runs, I think, if he stays healthy over the next 5, 6, 7 years.
Well, he's second on the club this year in RBIs.
Good glove. Great throwing arm.
Jams him, but he flares it out into right center field. That'll score one. Grubb comes around. And moving down to third is Evans.
Isn't that something? One little thing that turned out to be a big thing. Even with the walks, Jimmy could have been out of it. But the decoy by Whitaker will travel up, and they don't get the double play because Tony was pulled out of position. And he soft-tossed one to Manny Lee, who couldn't turn the pivot. It's led to 2 runs already.
That'll bring up the left fielder, Bruce Fields. The guy who spent 9 years in the Tiger organization in the minor leagues.
Also played on the same high school basketball team with the Magic Man before he went to Michigan State. Magic Johnson.
They called him up September the 1st. He's been hitting close to 500.
Costs, and he can make a fortune. He wants to sell you a franchise at $35,000 to do the lawyers out of some of their business. And he is Brian Lawrie. Now here is Steve with the rundown for tonight's show.
Native land claims. The future of more than 3/4 of BC is at stake, but negotiations have not even begun. Tonight, Webster begins a 7-part series with the leaders of the major tribal councils. First, the Carrier-Sekani in central BC. Their claim is the largest, 68,000 square miles. In the studio with Webster, Eddie John, chief of the Carrier-Sekani Tribal Council. Also tonight, where are your pension funds going? Who gets the surplus, you or your employer? Pension expert Byron Straight will explain. And an Ontario court battle spills into BC. Brian Lawrie thinks ex-policemen are qualified to represent you in court on a traffic violation, and it will cost you less, but the lawyers think that's dangerous. In the studio with Webster, ex-policeman Brian Lawrie and secretary of the BC Law Society, Frank Maczko.
Well, Mr. Lawrie, you're here to sell franchises, but first of all, we've got to know if you've got a product to sell. You're trying to do the lawyers out of business and winning in Ontario. How are you doing it?
We're doing it on a strictly common sense basis. Who else better to defend you in traffic court than the police officer who last week was giving you the traffic ticket?
Oh, no, it can't be that. You've got a force of ex-policemen who appear under your franchises or operations in court, not as lawyers.
As agents.
As agents. And what do?
They basically defend a person on the traffic ticket. A person is charged with a traffic ticket, they'll stand up, they'll cross-examine witnesses, they'll produce defense, or they'll adduce defense evidence.
Are you including criminal charges? If somebody's picked up impaired, does this ex-policeman who works for you or has his own franchise, does he take that into criminal court?
We just deal strictly with highway traffic matters, no criminal offences whatsoever.
And only in Ontario?
And only in Ontario so far.
How many policemen have you got, ex-policemen have you got doing this?
There are 17 with another 3 who joined me this month.
These are all old retired police officers?
These are young officers who quit between 10 and 20 years experience.
How much do you charge for a traffic, a defense in a highway traffic court?
We'll charge a fee, a flat fee with no disbursements, a flat fee of $150 to $290 for any particular offence under the highway traffic.
So much an hour?
No, it's a flat fee. We don't charge on an hourly basis. We tell the client exactly how much it's going to cost, and it doesn't cost them a nickel more.
So you might defend them on a charge, and it costs them $150, not as much as the punishment for that offence.
No, but certainly when you consider insurance and demerit points, it's a whole lot less than they would normally face.
So you encourage, and this has been quite successful. How many customers have you had, and how long have you been established in Ontario?
We've been established 2.5 years in Ontario. We've processed 3,500 thereabouts people through court. And the interesting thing is the Law Society of Upper Canada, which is the law society in Ontario, haven't had one single complaint.
Not one single complaint?
Not one single complaint.
But what I don't like about your operation is that you're out here to sell franchises.
I'm out here to recruit certain officers from the British Columbia police forces who would be interested in joining me and in doing this particular, providing this service.
Sell franchises. Simple question, witness.
I'm selling franchises. They're buying, but the public's the ones who are going to benefit.
How much does the franchise cost? I might want to go into business tomorrow.
Well, if you get $35,000, then I'd be happy to talk to you. And 10 years police experience.
And $35,000.
Right.
Well, now, here is Frank Maczko, the Secretary of the BC Law Society. I presume that your organization has absolutely no objection to a group similar to the one in Ontario appearing here as agents and doing your members out of a few bits of business.
Well, they won't do our members out of much business, but setting that question aside, this really isn't about defending traffic tickets. This is about selling franchises, and I'm sure you've seen these before, Jack, but essentially the trick is to, first of all, declare war against some establishment organization. Then you make this announcement to the press, and you sort of send a news release to all the people in the press. Then you come to town, sell a bunch of franchises, and leave town. I mean, this is a common
no, you can't
operation.
accuse him of that. You can't
It's
accuse him of
interesting
that.
that, say, never having met Mr. Maczko, really, that he should be able to predict what I'm about to do. That is not what we do at all.
Well, let me just finish my point. What I was saying was that this is a common pattern. That's true. I haven't met Mr. Lawrie other than last Friday, and I'm not suggesting that he did this. I'm simply saying that this is the pattern, which is a common pattern that we've seen happen in British Columbia time and time again. There's nothing unusual about this franchise operations. Now, that deals with that aspect of it for anybody who buys it.
What about the legal aspect?
The legal aspect of it is fairly simple, and that is that if anybody buys that kind of franchise and tries to operate in British Columbia, they're simply breaking the law. It's against the law to act in these cases. It's as
Whose
simple
law?
as that. It's against the provincial law known as the Barristers and Solicitors Act.
Oh, you got it tied up tight.
We got that aspect of it about appearing in court tied up tight.
Tell me, be specific, because he wants to know this, or he's wasting his time.
Well, the Act, which is the Barristers and Solicitors Act, simply provides that for anyone who appears in court as counsel or advocate must be a member of the Law Society. Now, there are some exceptions to that. So
Like,
there
I can appear in court for my father, my brother, my mother, and help him to give his explanation.
That's right. That's right. And you could do that as a friend or for a friend. You can do it for yourself. And there are some other exceptions as well. The Court Agents Act deals with it very specifically, and that's a provincial statute which simply provides for those situations where someone can appear as counsel for someone else. And that includes areas, for example, where there are fewer than 2 lawyers, so that people can get
All right,
services.
let me stop you there. You say that, do you say on the face of it that Brian Lawrie's proposed operation, modeled on Ontario, would be against the law in BC?
That's right.
Would you, if he sets up, will you take action against him?
I don't know whether we would or not. It would depend on what happened, actually. First of all, if they appear in court, it's contrary to law, so it's unlikely that a judge would hear them, simply because a judge wouldn't
Have you
participate in
researched
it.
this aspect of the British Columbia Legal Professions Act, or whatever it was?
I certainly have. The Act is, I mean, it's a tremendous protectionist piece of legislation. It's a better written franchise agreement than mine is. How else, as a businessman, it really makes me drool, because what it does is it legislates all your competition out of the province, and if they come in here, they're able to, they're liable to 6 months in jail. Now, the interesting thing about this is that the Court Agents Act, it deals with, I could do all of this if all the lawyers would move out of Vancouver, then according to the law I can do it. But because there's so many lawyers in here, I can't. Now, that's like McDonald's saying to, you can make hamburgers all over the place, but when we open a McDonald's store in the town, everybody buys from us. Totally ridiculous, really.
All right, now let's get to the other aspect.
Well-
He's saying that they're only act for simple highway traffic offences. Do you concede, Mr. Maczko, with all your vast legal experience behind you, that an ex-policeman is just as good as a lawyer in defending a simple traffic ticket?
He might well be. I mean, I don't know that. But really, when he puts the argument on that basis, it goes to the whole foundation of any professional statute. I mean, one can say that an orderly can put in stitches just as well as a doctor. I mean, that's possible. But the law is that you don't have orderlies put in stitches. They're done by interns
Next
or by...
point, he says from, what was your range, 150?
To $290.
That's much cheaper than if you wanted to use a lawyer to fight it, is it not?
No, it's not much cheaper than getting a lawyer to fight it at all. In fact, at $150 range, in that range, you can certainly get article students to do it. These people are are people who had 7 years of training. They've been trained to do court cases, and they do it under the supervision of a lawyer, and they can do it at least that cheap, so that they don't do it any cheaper than article students would
Are
do.
article students as good as your people?
They certainly are not. I mean, an article student, he steps out of college. I should imagine that the syllabus in the BC Law School is the same as in Ontario. In Ontario, the Highway Traffic Act here, the Motor Vehicle Act, doesn't appear on the syllabus at all. What do they know? They come in, they're sent along there basically because the lawyer can't be bothered. There's a vacuum there, and we're filling the vacuum, and we're filling it remarkably well.
In Ontario?
In Ontario, and we will in BC.
Well, but that, Jack, to say that that's true is like saying that an orderly can do stitches just as well as an intern. I mean, that just isn't so.
But an orderly can do stitches just as well as a practical nurse, maybe.
Maybe, but neither of them are permitted to do it because there are consequences which might flow and other problems. For example, let me just give you a couple of illustrations. One of the purposes of professional legislation, whether it's doctors, lawyers, nurses, dentists, and so on, is to be able to control the conduct of the people who do it. And you have problems of discipline, compulsory insurance programs, special fund insurance, all of these sorts of things.
But they won't have any trust funds to walk away with.
Sure they will. The people will
Would
pay
you have
fees.
trust funds to walk away with?
We don't have trust funds at all. I mean, this is cast up to us, and it has been in Ontario. It's a deja vu sitting here. What happened in Ontario was that they say that the people need protection. The people were not qualified. I mean, if an orderly has been doing stitches for 15 years, putting stitches in people's fingers, then what's wrong with them putting stitches in
Okay, gentlemen, the issue here, you say, is the unauthorized practice of the law. The issue you say here now in British Columbia is this monopoly combine of the lawyers, and it would assist the public if your people set up here could appear in these minor traffic matters.
That's correct.
The issue here is sale of franchises, not doing traffic tickets, Jack.
Have you got a quick 35,000?
No, the issue is money. That's basically it.
Making a living.
Making a living.
Good. I'm going to go to the phones now and see what kind of public responses are for Maczko or for Lawrie or against Maczko or against Lawrie, with me sitting classically non-partisan in the middle after the break. Brian Lawrie from Toronto. Points, Provincial Offences Information and Traffic Ticket Service Limited. And Frank Maczko, Secretary of the Law Society of British Columbia, and this call. Go ahead, please.
Yes, I just moved out here from Ontario, and I'd really like a response from your lawyer there. A friend of mine is currently attending U of T. He's taking the bar. He's going to be a lawyer. Now, he ended up using points, I would say, about 3 months ago to help him, because according to him, even his teachers didn't have the experience that the police did.
Okay, good question.
Oh, I think that's quite true. The teachers in law school generally don't have the experience. They teach theory of
Didn't you used to
theory of
teach
law.
there?
I spent 6 years on the faculty, as a matter of fact, and if I were, as a matter of fact, I was charged with speeding one time, a long time ago, and when I was, I hired a lawyer. It doesn't surprise me at all that he wouldn't hire one of the teachers, or a teacher there would hire a lawyer.
So you concede that this guy would be better than a lawyer?
No, I don't concede that. He would be better than a law professor.
Okay, boy. Go ahead, please.
Hello.
Yes.
My comment is in regards to the analogy of putting in stitches. I think it's an example of the type of monopoly that both lawyers and doctors have. I don't think there's any need for that type of monopoly, especially in a matter of such a thing as traffic tickets.
Thank you. Did you stack the deck tonight?
This is what we've been saying all along, and this is precisely the reaction in Ontario, and it's going to be the reaction here despite the Law Society.
But what's these franchises? We don't like them. Go ahead, please.
Yes, I'm with the gentleman from Ontario. I don't think he won't be able to get in with the people who are passing all these laws. The lawyers have got everything in this province tied up, so that, he doesn't have a chance of having any legislation passed.
Oh, but
I
forget.
hope he does it, though.
Do you like the points idea, yes or no?
Yes, I do.
Thank you, sir. Your image isn't all that good tonight.
Oh, I don't know that that's true. It's not a question of image. I mean, I can understand people's reaction to that, and that is if somebody comes along and says, look, I can provide you traffic defense, it's cheaper. Of course everybody's going to be in favor of that. The fact that it isn't true doesn't have a whole lot to do with it. It's simply that anybody will be in favor of it if it were so.
The Law Society is cheaper. They revolve around money the whole time. They did in Ontario. We come along and we say we can do it better and cheaper.
Okay, go ahead.
That they can't dispute.
Go ahead, please. Go ahead, please.
Hello, I'd like to know why the Law Society is so upset about what is apparently something that's piquing interest in their profession, and therefore probably make more money for themselves. If I was them, I'd probably sit back quietly, just let the storm blow over, and laugh all the way to the bank.
Well, the truth is the Law Society isn't upset. What happened was that the Law Society, and by that you mean the ranchers, have never put their minds to this. The reason I'm here is because Jack phoned me up and asked me to come on, or his researcher phoned me up and asked me to come on. That's why I'm here, and I'm simply here to explain the law and explain the position.
Good, thank you.
We're not upset at all.
And I'm grateful to you for coming, and so is Brian.
Right.
Go ahead, please.
Yeah, I think they got a great idea there, and let's get a little bit of competition happening and see these lawyers, you know, clean their act up a bit, get a little more realistic, and you know.
We must find a call in favor of you.
Yeah, but just a minute. You see, it's just so long as you pose the questions in those ways and make the statement that lawyers are ripping people off, that's in essence what the argument is.
No.
It isn't true.
No,
it's just plain wrong, and you know, to keep saying that.
It costs more to get a lawyer, but if it was an important thing, I would no more trust one of his ex-policemen.
So look, here's what it comes down to is this. If you've got your first 3 points, most people don't defend. So that end of the market is not going to buy. In other words, they don't get lawyers nor non-lawyers. At the other end, when somebody has got 9 points and they're facing a loss of license, would you hire an ex-policeman? You'd hire a lawyer to do that because you want a Cadillac defense. In between, there is, you might say there are some people in there, but
he has a good point on that.
Well, you see, if you have 9 points, why not? Why would you hire a lawyer who may have never been in traffic court? Why not hire somebody who knows something about it instead of somebody who arrives in a Cadillac?
No, you hire someone who has been in traffic court and indeed has had the experience.
We've got
That's
many
what you
lawyers
do.
who are expert in traffic courts.
Absolutely.
Go ahead, please.
Hi, I think this trend is kind of part and parcel with the negative reputations lawyers are encountering now, and I think as a group they bring it upon themselves by the improper policing of their profession.
Well, give me an example of what you call improper policing.
Well, I think the Canadian Bar recently in the paper talked a little bit about the fact that they're encountering as a profession a decrease in the reputation. That given the average person on the street in the various professions throughout Canada, the legal profession is dropping down in the ranks.
Yeah, but what's your point about improper policing? You said that we do not properly police. What does that mean? Give me an example.
Generally, the person on the street, whether they're in front of a traffic offense or criminal charge, or even just formulating a private company, feel that they're not getting the best people to do it. They're being overcharged when it is done, and generally the lawyer is passing it on to some sort of a paralegal or a legal secretary and having it done anyway. So I see this trend as this ex-policeman is coming in and saying that, as he said, there's a vacuum there, we can do it better, and we can charge less.
Fair enough. There's another trend for which the legal profession, I suppose, must be complimented, and that is the fact that you're opening up competition to the extent of advertising nowadays.
We've had lots
which is an improvement.
We've had lots of competition in this business for years. Notary Public, our competition. We've got unlimited advertising by lawyers. There are way more lawyers than needs to be to service.
Is there not room for his people regardless?
Well, I don't know whether there is or not. One of the things that the legislatures have to be concerned about is that when they permit people to deliver professional services, that they're properly monitored and controlled and exercise the ordinary discipline functions that go on.
Good point. Answer that.
In my specific case, these people that are employed by me, they're coming in, they were employed by the Attorney General to do the same thing on the other side. They've already proven their qualifications. They've been qualified by the Attorney General. They just step over and they step on the other side.
Go ahead, please. Hello.
Jack, I think we've got a situation here that the Medical Association was facing years ago when Emergency Health Service paramedics came into being. They were reluctant at first to take them, and the Emergency Health Service paramedics have proven to do a wonderful job. I think these lawyers should take a back seat to these fellows and let them show their stuff.
Thank you. Where am I going? Campbell River. Go ahead, please.
Hi, Jack. What I would like to know is, in the traffic courts in Vancouver, there is a backlog of cases. I would like to know why the lawyers can't step aside and let this gentleman and his group come in if they are properly screened.
I don't think there's any relationship between the backlog and the legal profession.
No, as a matter of fact,
many of them are lawyers that
No.
are handling these cases.
no, that's not true. The fact is that not that many lawyers actually go to traffic court. The backlog, such as it is, has nothing to do with the legal profession at all. Indeed, what you find is that the more people you get into court defending, such as lawyers, paralegals, or whoever you want to use, that increases the backlog, not decreases it.
The reverse has been found in Ontario. I must challenge that statement. Because of what happens, a citizen goes along, he's unrepresented. The procedure has to be explained to each and every citizen. When we use paralegals, we go in, we know what has to be done, it's done, and the whole procedure is expedited, and that's been proven over the past 2.5 years.
Go ahead from Victoria, please.
Oh, Jack, I'm an ex-policeman, and I can assure you that a policeman would know, particularly a traffic policeman, would know far more ways of defending a case in which he has issued a ticket or has in the past issued tickets. Lawyers just do not have the experience in this kind of thing. They're not experts at it.
Well, fair enough. Frank disagrees and he agrees, doesn't he?
Well, I guess there's a difference of opinion about that.
That's what makes the courts go round. Go ahead, please. Go ahead. Where are you?
Jack.
Yes, that's you.
Oh, yes, Jack. Just concerning your last caller there, I would certainly agree with the last caller in so much that a policeman would have a lot more experience than the average lawyer. And to my knowledge, I wouldn't imagine a lawyer would specialize in such, such an area as the Motor Vehicle Act, because the money wouldn't be there. And the other thing is, I'm wondering, I missed the beginning of your program. Why would it cost $35,000 for a franchise?
I'm glad you asked that question because I'm just about to question Mr. Lawrie on that. How much money would I have to gross? How quickly do you want the $35,000, which seems extraordinarily high? What do you give for the $35,000? What are the repayments? What's the interest? And how many people would I have to employ to pay back the $35,000?
The situation as it exists in Ontario is that the $35,000 is an Ontario figure. The first franchise was sold for $2,000, and it has increased on a steady basis.
Did you sell that franchise?
I certainly did.
The whole thing is your idea?
It certainly is.
So now the market value in Ontario is $35,000?
It certainly is.
What's that guy grossing a year, though?
Over a period of a year, he's going to gross somewhere in between $50,000 to $70,000.
And he's paying you off by installments, I presume?
Basically, I work in agreement with each and every one, depending on his financial circumstances, but some of them are paying me off in installments, yeah.
Mm-hmm.
You see, Jack, see what happens in these interviews, like always, you pick what appears to be a soft spot in every profession like this one and start to talk about we can provide things cheaper. The fact is, what we're talking about is selling franchises at $35,000.
That's where you'd make your money.
Well, no, I make my money on
That's what the operation's
I've got to leave
about.
it at that, and I'm glad you came. You're probably running a good operation in Ontario. You know about the franchise, and Frank Maczko, the Law Society, looks down his nose at the whole operation.
All I say is this. Anybody who pays $35,000 needs his head examined to franchise anything of this sort.
My thanks to Brian Lawrie, Frank Maczko. Next, I'm going to talk about pensions after the break. Every employee in Canada, if he's got a pension coming up, is interested in this issue. And I've asked, and it's because of a case in Ontario, Dominion Stores, Conrad Black, where the employer lifted $38 million in surplus funds out of the pension because the employer said they belonged to us. And it raised the Supreme Court of Ontario ordered Dominion Stores to put the money back again. Now, I asked my good friend Byron Straight, a pension actuary, to come and tell me if this is a matter of great concern to every employee in Canada who has his pension in a fund other than provincial or federal civil servant pensions.
It depends on the type of pension plan, and it depends on what the pension plan says. In this particular case, the plan started back in the 40s. It was a plan where the employee was required to contribute, mandatory. In 1977, it came under the collective agreement with the Retail, Wholesale, and Department Store Union. In 1979, the pension plan was amended, presumably with the knowledge of the union. Prior to amendment, the pension plan said that if there was any surplus on termination of the plan, it would be distributed among the members. That probably came about because in 1959, the Revenue Canada stated in their Principles and Rules and Information Bulletin governing the registration of pension plans that the pension plan had to provide that when it was terminated, all the money would be distributed among the members.
All of the money.
Right.
Terminated.
And in 1960, they withdrew that Information Bulletin 14, but they said they kept on using it as a guide. And so pension plans for a long time had the provision in it on termination of the plan that all the money would be returned to the members. But when that requirement was no longer one of the requirements for registering pension plans, some actuaries continued to use the same wording. Now that wording was in the Dominion Stores pension plan, and in 1979 the company amended it to say that on termination of the plan, after they'd paid off all of the liabilities, met all the obligations, the surplus could return to the employer. In this particular case, the plan was not terminated. It was badly overfunded, and the employer wanted the overfunding to be returned to the employer, not on termination of the plan, but while the plan is still operating.
To use for his own benefit.
Yes. There are really two reasons why there was so much surplus. One is that the pension fund's investments were performing remarkably well, had a return, I am told, of over 15% average for the last 10 years, most of which I think was obtained in the last 3 or 4 years. Big gains in the last 3 or 4 years because bond prices went way up in value. You could get a 40% return in 1 year because interest rates dropped. Stocks went way up in value. So there was a recent period of time when pension funds performed very well at a time when inflation was moderating and salary increases and wage increases were moderating. So the fund was doing very, very well.
But the courts ordered that money to be put back into the pension fund.
Well, in this particular case, there were a lot of layoffs, a lot of stores closed. It was a sort of a partial termination of the plan. And the record shows that the union attempted to get a hold of the Ontario Pension Commission to state its case and was repeatedly ignored. And the judge or the judges came down hard on the Ontario Pension Commission for not giving the union or the members of the plan their day in court.
And that's what happened. So Conrad's people had to pay back the $38 million.
The money was ordered to be paid back without determining who owns it.
That's still to be decided?
Yes.
Now, what about generally speaking, therefore? In British Columbia, is there any legislation which allows an employer, if money has been put into a pension plan and has considerably increased, should that money not stay in there and increase the pensions of the employees? Or, if times are bad, can the employer take that money out and do with it as he wishes?
Well, if the employer has made a mistake and has contributed too little, he has to make supplementary payments to bring the funding up to scratch. By the same token, if he contributes too much, he should be able to take the money back as a part of a going concern and a going funding program. If we didn't have these carryover words about everything being distributed to the members on termination of the plan, the same thing should occur on termination of the plan. So long as the plan provides for all of its promises and meets all of its obligations and there's still surplus left over and the employer is guaranteeing the plan and guaranteeing the performance, if there's money left over, he should be allowed to have it back. But if the pension plan says he can't, then of course it's a matter of law and he can't get the back.
We don't have a provincial statute which says money's put into a pension plan must stay there with all the benefits accruing to the employees.
Well, pension legislation, that is the legislation governing the operation of pension plans in the various provinces, doesn't seem to be any help. Regular laws, statutes and common law,
trust laws,
they're the ones that determine the right to the pension and the right to the surplus. There have been other cases in the East where a pension plan said that on termination, all of the money would go to the participants, and the employer unilaterally amended it to say, I've changed my mind, and it won't. And the court said, sorry, but that isn't a proper amendment. You can't do that.
Well,
but in BC, there have been 2 cases where the reverse has occurred.
And give me the reverse.
Well, the employer said that first that all the money would be distributed when the plan was terminated, and then later he said, after all of the obligations have been satisfied, if there's any money left over, I can have it back. And an argument can be put to the participants in the plan that they're getting everything they're entitled to, perhaps even some bonuses, and will they approve of the surplus coming back to the employer? And you might get the participants in the plan, that's the pensioners, the employees, and the beneficiaries, to agree to it. Sometimes you might have to get the public trustee to agree on behalf of some of the people. But even without that, it's possible that you can, because of the wording of the pension plan, you can determine that the payment of all of the obligations of the plan in the order prescribed on termination is sufficient. And if there's money left over, you've created a new trust, and the new trust fund should go back to the settlor. Now, I happen
Who's the settlor?
The people who put the money in,
Right.
the people who have title to it. And those two decisions in BC, I think, are in conflict with what's been happening in Ontario. We're into the area of law here. I'm not competent in law, except that I don't understand the difference between what's going on in these two cases in BC and what's going on in Ontario.
But broadly speaking, what I've learned from you tonight, though, is that in normal circumstances, where the employer has got enough money, or where the pension trust of the company has got enough money to meet its obligations in the future, if they close the doors tomorrow, that any surplus, in a logical manner, a profit made on it, having satisfied the pension needs of the employees, would belong to the shareholders of the company.
If the plan says so. If the plan says so.
Should people worry about checking if the plan says so? Or?
I don't think the participants should worry, but I think the employers that have a lot of surplus in their funds should check to see what they can do about that surplus, whether the plan is terminated or not. There are methods of creating a new plan and getting all of the participants to agree to accept the new plan instead of the old plan.
Are we over-pensioned?
I don't think so. There are plenty of people who aren't in pension plans at all. This particular plan, the Dominion Stores plan, was a bargain plan, but it was not bargained in the sense that most union-negotiated pension plans are bargained in British Columbia, where the union has half of the control of the fund or all of the control of the fund through the appointment of trustees. In the Dominion Stores case, the union blessed the pension plan text but didn't particularly have any control over the fund.
Byron, you're a gem as an actuary. You really are. I'm going to ask you to stay there in case there are any questions on this pension thing, and I'm also going to take an element of free-for-all if it's required to keep the program bright and breezy through the next segment before we come to the Indian claims from the Carrier-Sekani. Free-for-all and Brian Straight after the break. We're going to go to the phones, but one of the reasons the Dominion Stores decision intrigued me was because somebody suggested that this decision of putting the money back may put a nail in the coffin of defined benefit plans where the employer promises to deliver a specific pension.
Well, it may make some employers hesitant to fund safely.
Commit themselves. Go ahead, please.
Yes, I have a question, and firstly, it has to do with the fact that even in a defined benefit pension plan, if the funds come out of the plan and after the money, it's been determined that there's enough money there to provide the benefit for the rest of the life of the policy, there's laws concerning the taxation of that money because the companies have been taking, or the employees and the companies have been taking tax deductions from that, from their, or tax deferrals from their taxes. Those would have to be addressed too, would they not? I'll hang up and listen to your answer.
Well, a return of surplus to the employer is taxable. Any benefit, any payment out of a pension plan is taxable. That was the original reason why the Revenue Canada did not want money to come back to an employer, because in the Canadian abattoir case, a large refund was paid out of the pension plan back to the employer without tax being paid on it. It was treated as a fortuitous gain. And that was really one of the reasons why Revenue Canada didn't want any surplus ever to come back to an employer. But now it's specifically taxable under Section 56(1)(a).
Go ahead, please.
Hello?
Yes, ma'am.
Is it legal for my pension plan to say that if you're over 45 and have done 10 years service, that on termination you cannot get your contributions back?
Not in British Columbia. If your employment is in one of the provinces that locks in your contributions and you're
Like the BC Imperial Life Plan.
I don't know what you mean by the BC Imperial Life Plan. But
No, it's in BC, the province of BC.
if it's in BC, sometimes people work for an employer that has the same plan all across Canada, regardless of the distribution of the employees. And if that plan is required to lock in the employee contributions on termination after age 45 and 10 years of service in Manitoba, Ontario, Alberta, Saskatchewan, etc., they'll do it for BC employees as well, just to be uniform.
And there's nothing you can do about that?
Yes, you can complain about it.
Oh.
Can you win the complaint?
Should be able to.
Oh, thank you.
Go ahead, please.
Yes, my question is if the company has already put into its pricing structure, pricing mechanism, the cost of the pension program, and it has generated its profit, why should the company be entitled to a return on an additional return on its investment in the pension fund, since it's been costed out according to in its pricing? Why should it be entitled to a further return? I'll just hang up and listen to your answer.
In a plan where the employees contribute, the employee contribution rate is fixed. The benefits are not fixed. The age distribution is not fixed. The wage and salary increases are not fixed. And the employer employs an actuary to tell him how much he should contribute. And in most cases, the actuary makes an informed guess as to what the costs are. He has to assume what the fund will earn. He has to assume what percentage of the employees reach retirement and so on. But he can make mistakes. He can make a nice mistake. The fund might earn too much. In that case, the employer is entitled to reduce his contributions. But if the plan is also shrinking and there are very few employees in the plan, it's very difficult for the employer to get his surplus back by withholding contributions on a very small group.
Good point. Go ahead, please.
Mr. Straight.
Yep.
I had 20 years service with the same company, and it was based out of Ontario, and my pension plan was locked in at the age of 45. Although I think you've already answered part of the question earlier, but although I was employed in British Columbia, I guess my best thing is, as you said, is to protest.
Yeah, so they're not required to lock you in British Columbia. All they have to do is vary the terms of the plan to say so.
I see. So my best bet would be to go through my legal counsel to try and see whether they can release it.
Yes.
Thank you very much.
Go ahead. You're giving some people what might be encouraging news.
Hello?
Strange from an actuary. Go ahead, please.
Hello? Yes, I'm inquiring about my mother-in-law. She's a teacher, or she was a teacher. She was paying into the teacher's fund for 23 years. And then when she became 65, she couldn't get her full teacher's fund, teacher's pension, and her Canada pension. I was wondering why.
Well, you can't.
I don't know what you mean about the statement she couldn't get her pension out. You mean her contributions, or?
Oh, the Canada pension, she gave her the full check, right? But when she got her teacher's pension, they would only pay her half. They said that she wasn't able to get the other half.
I don't understand that.
Okay, we'll just leave it. Go ahead, please.
Hello.
Yes, ma'am.
Does the BC law provide us with enough protection that we can depend on our pension plans?
Good question.
I'll hang up and listen to you.
There are no particular laws in British Columbia dealing with pension plans per se, except references in certain statutes about naming beneficiaries and that kind of thing. But there is no law in BC, as there is in other provinces, requiring the employer to meet current service costs and pay past service deficiencies off in a stated period of time. Not that that legislation is particularly useful, but there is no such legislation in BC.
Should we have it?
If they have useful legislation, they should have legislation. But the early legislation in the provinces, in my opinion, was virtually sham legislation. It achieved nothing except annual filing of reports. But now the legislation is quite tough and strong enough to achieve things and could be used in British Columbia.
Go ahead, please.
Hello, Jack. I'd like to ask your guest a couple of questions here. I work for a company on Tilbury Island in Delta, and I was just wondering, we had a plan that was an employee contribution plan. And now, as of January the 1st of this year, we've gone to a non-contributory plan. But the plan said that the surplus will only be used for the benefit of the participants. Now, there's $700,000 here that's in question. I've got a good union man in the background. You can hear him screaming.
Right.
And $450,000 of that was used to bridge benefits for retirees in another plan. And another $250,000 that I'm talking about was based on a 25-cent per hour increase that the company was supposed to pay per hour to every employee, and that was negotiated in 1980. And we found out that money was being taken out of the surplus.
I don't know if you can cope with that one, can you, Byron?
Depends upon what the collective agreement says. If the collective agreement requires the employer to cause a stated amount of money to go into the fund, he could use any money he wants, not necessarily his own money.
Right. But what happened was the company unilaterally made a change that was approved by the Alberta Pension Committee, whom we're registered with, or the Alberta
Pension Commission?
That's right. That's right, Alberta Pension Commission, that any surplus would go to the company. Now, here we are in midstream, and, someone decides in Alberta that,
just a minute,
company, go ahead and put your meat hooks on the money.
I've got to take this count. Can you solve that quickly, or just...
You have to examine the plan documents.
That's the only answer.
So I just thought I'd let people know that...
Good, I'm very grateful, and I think it made sense to most people. As you'd made remarkably good sense to me tonight, Byron Straight, pension actuary, a man in a most esoteric profession, but capable of being understood. Thank you very much, Brian, sincerely. I'll be back after break. The next Indian land claim I'm going to deal with is that of the Carrier-Sekani Tribal Council. And you can see the area it covers. And with me is Edward John, who's a lawyer, who is the tribal chief of the Carrier-Sekani. How many big towns are within your land claim?
The biggest one, of course, is Prince George. We have Fort St. James, Vanderhoof, Fraser Lake, Mackenzie, Burns Lake. Those are the bigger areas.
What area in square miles is it not the biggest one in British Columbia?
It is the biggest tribal territory in the province. The estimates I've seen are 70,000 square miles.
If I can put in a little needle, is it not overlapping on the Gitxsan claim?
It is with the Gitxsan and with the Wet'suwet'en, and there's an overlap there that we've committed ourselves with the Gitxsan and the Wet'suwet'en to resolve through our traditional and customary laws.
In other words, if you get the land claims, there'll be no trouble between the Gitxsan, the Wet'suwet'en, and the Carrier-Sekani on the actual boundaries.
No. In fact, we're close. We're a close people.
How live is your claim at the moment?
It was submitted in 1982. It's not been negotiated. It's been accepted for negotiations by the federal government in 1983, October, about 3 years ago.
But you have some legal actions in court right now based on your Aboriginal rights, do you not?
That is correct. We've just been added. We've applied to be added as a party in the action that started in 1980 between the Fisheries and Oceans and the Aluminum Company of Canada, Alcan. I believe in 1985 the BC government was added as a party on their own in the court action, and this year, because of the pleadings and the nature of the court action itself, we decided that, our people decided that we had to become involved.
Well, what do you want? Alcan has been a great employer of labor, contributed mightily to the province of British Columbia. What do you want Alcan not to do?
Well, first of all, let's consider what they did. They created jobs in Camano, fine, yes, we have no quarrel with that, but what they did was they flooded our people out in the Chislada, the Utsa Lake area. The people were flooded out in the spring of 1952. They were told on short notice, the water's rising, you have to leave. And these people had communities set up on the shores of that lake. Downstream from the dam, they dried out the rivers so that the salmon that spawned in those rivers were directly affected. Even now, you can see the water level in the Maczko River. You can walk across the river.
In other words, they were denied any reasonable treatment at that time. And are you negotiating on that basis now for damages from those days?
We've, through the Chislada people, filed a claim with the federal government of Canada, which has not yet been accepted, claiming for damages arising from the impacts to those people in that area. But in the court action, we're also seeking a declaration of Aboriginal title to say to the courts to say that yes, the Yinkadane, who are the people that we call ourselves, do have an Aboriginal title and Aboriginal rights into our traditional area.
That action you could take anyway without a land claim, though, couldn't you?
We can take that action, but in this case, the action between the Fisheries and Oceans, the Attorney General of Canada, and Alcan deals with the river system and has direct impacts on the salmon.
Your claim encompasses Prince George, Vanderhoof, Burns Lake, Fort St. James, Mackenzie, with all these huge developments.
Yes.
Are you being specific in what you don't want? Are you saying to people of Prince George, we're going to take your title away?
No, we're not saying that. What we're saying is that this is the traditional territory of the Yinkadane. The land claims, it's called land claims, but it's a traditional territory of the Yinkadane. What we are saying is we want to be able to sit down with the government of Canada and with the government of British Columbia, who've divided the jurisdiction and the authority and the lands and the resources between themselves. We want to sit down with them and negotiate an agreement for our people. Our people do not have direct access to resources or like the other tribes in this province. Very few people that are employed, high welfare rates.
But what do you say to the likes of Vanderzam or Brian Smith, who say, in British Columbia, everyone shares in all of the resources, no special deals or treatment for anyone?
Well, I would like them to share in the misery of our people. I'd like them to share in the kind of housing that we have. I'd like them to share in the kind of education that our people get. I'd like them to share in the suicide rates of our people. I'd like them to share in the high welfare rates of our people. And then I'd like to hear what they have to say.
Can none of the blame be put on the Aboriginal peoples themselves?
I guess partially we can say we can accept some of the blame. Part of the blame is that we were too darn nice.
Too darn easy to get along with.
We treated the settlers well. We welcomed them with open arms. We fed them. During the winter when they were starving, we've done that. That's our history, and we've welcomed people into our territory.
But that was a long time ago. There is no possibility now, is there, for homogenization of the peoples, is there?
I don't know what you mean by
well, all mixed together as one. I mean, the Indian tribal culture and life is secure in the Carrier-Sekani.
It's secure, but it's shaky. Part of the efforts of our people have been to try to rebuild our communities. Like I said, we've been struggling with domination from outside forces. We've been struggling with language matters, where our language has not been part of the curriculum, not part of the residential schools in the past, and you know.
Are they all gone now, these residential schools?
The one residential school we've had in our area is gone as of 1976.
Is the public school education not satisfactory for Indians in your view?
Well, they don't have curriculum that deal with Yinkadane. They don't have language that's Yinkadane language in their curriculum. They don't have history of our people in their curriculum. So it's, you know, slowly over a period of time they're teaching non-Yinkadane
I understand
history.
that. You're losing all your culture, all your background, everything.
Not if we have anything to do with it.
And that's what I mean. How many Yinkadane are there?
We estimate approximately 10 to 12,000 altogether.
Now, if I were, for some mysterious reason, negotiating with you, I'd think, now, what you want is a recognition of your traditional rights, your Aboriginal rights, and financial share of resources so you can build your own schools, your own technical training, and go your own way.
Well, we want to do that. We want to be able to be in a position where we decide for ourselves. But I have to tell you a story about the elders in our communities are saying, showing us a dollar bill and say, you see this money? They said it's worthless. You don't go after money in any claims negotiations. What you are looking for and what you have to talk about is land. Money is absolutely worthless.
Land.
The land is the important thing. The resources on the land are the important thing.
This is the advice from your elders.
That's the advice from the elders, and I think there's no better advice than that.
And the advice is, don't be bought off with $1 billion in cash or $6 billion or $500 million. Get the land.
That's what's been told to us. You know, obviously we are going to need some financial resources to help us in setting up schools, in helping us developing curriculums, things like that. But the major thing is the land and the resource. That's how BC operates. That's how this country operates. The wealth of the land and the resources.
My thanks to Eddie John, tribal chief, correct?
Yes.
Of the Carrier-Sekani. I'll be back after break. Tomorrow on the program will be the claim of the Nishkas, and the person on will be Rod Robinson. Tomorrow I'm also going to interview Pierre Genio, the president of Air Canada, our flagship airline, to see what's going to happen under deregulation, why they're losing so much money nowadays, and what the future holds for Air Canada and for air traffic generally in Canada. Tomorrow with Webster at 5 p.m. Stay tuned for the news hour.